You, if you want to call the meeting
Okay,
to order.
let's open up the meeting.
All right, very good. All right, begin with the reading of the Open Public Meetings Act statement on February 9th, 2024. Notice
I'll
of
make
this
a
meeting.
motion, we accept the minutes.
Yeah, I got to finish reading this. On February
Okay, go
9th, 2024, notice of this meeting was placed on the official Bellmawr Redevelopment Agency website and emailed to both the Courier Post and Gloucester City News newspapers for publication. The official notice to Borough Clerk was emailed on February 9th, 2024, which included requests for posting of the notice to the official Borough of Bellmawr website and bulletin board. All requirements of the Open Publics Meeting Act have been met in compliance with the Sunshine Law. Brings us to the flag salute.
I pledge allegiance to the flag
to the flag of the United States of America,
and to the republic
and to which it stands,
one
one
nation,
nation, under
God,
God,
indivisible,
with liberty and
liberty and
justice
justice for all.
All right, brings us to a roll call. Chairman Frank Philippek,
Here.
Vice Chair Ray Bider,
Here.
Commissioner D'Angelo,
Here.
Commissioner Capados, Commissioner Whitman,
Here.
Commissioner Patel,
here.
and just want to make sure Jeff didn't join. Commissioner Simpson. All right, standard agenda for this evening brings us to the reading of the minutes from the previous meeting, which was the reorganization meeting from January 30th, 2024.
I make a motion, we accept the minutes.
I second it.
Second.
All right, I got the chairman on the motion and I got Mr. Patel on the second. All in favor signify by saying aye.
Aye.
Any nays? Ayes have it. Brings us to communications. We did not receive the redevelopers report as of yet for February. And the traffic engineer's report, he had suggested waiting until March to submit his Q1, as there hasn't been any reportable activity that's of note. So we'll expect that at next month's meeting. And then I know Mike will brief on on that letter that I distributed from our special counsel environmental, Deb Rosen. Just 1 second, our engineer is joining. And that reminds me, I apologize, forgot during the roll call, Executive Director Josh Tregear, I am here. Solicitor Mike McKenna.
Here.
And Dennis McNulty, engineer. Dennis, you on? He's on and I can see
Dennis.
him. Yeah, I see you. He is on.
You're on mute, Dennis.
Yeah. Okay.
He's waving.
Yeah. He just muted himself. I don't think. Yeah.
Let's do hand signals.
Dennis, you hear me?
There you go. Now we got it.
All right. Just for roll call. Dennis McNulty, engineer.
Present.
All right. Thank you. All right. All right. So that brings us to commissioner reports. If anybody has anything. All right, and that brings us to executive director's report. As we know, last month at the reorg meeting, we adopted the budget for 2024. That was then submitted to the NJDCA for approval, and that was done on February 9th, which then, per requirements, was posted to the posted and published on February 9th, 2024. With that, we are completely current now with the state in terms of our financial reporting. So up next will be the audit for 2023, which I've already been in contact with Bowman, and we're targeting late April, early May to begin working on that. In addition, professional service contracts, again, they were awarded at the reorg meeting. So with that, they were notified, and we'll work with Mike's office to get the contracts executed for 2024 with all the individual parties there. I don't know why this is jumping on me. Communications, just making the normal updates coming through the website for any updates, right? It's needed that that occur year over year. And that's about it. So, any questions for me before I turn it over to Mike?
Nope.
All right, Mike.
All right, so we can dispense with the first issue, review redevelopers report. As Josh indicated, we do not yet have hours, and as you also recall, last month we had just received it on the day of. And I don't fault the Redevelopers Council. Reporting to us monthly is a courtesy, and it's helpful when there is progress. But right now, there is an enormous amount of activity going on in another sphere, which is the mayor and council. They are renegotiating and talking and understanding each other's positions on a wide variety of issues, but they are all issues that are solely within council's domain, and that ultimately will become part of our assignment by council. And that's how we serve. But those things about like the pilots, the intermunicipal agreements, the arrangements with Deptford, those are all things that are going ongoing. Mr. Long has all of those issues well in hand. He's got competent expert counsel from Parker McKay's office. They are interfacing with mayor and council separately. Howard does keep me abreast of things, and I appreciate that. It's always helpful for me to at least understand the process and to know when the ball's about to be thrown back to me. So I can tell you that I remind you all that I had some questions for Mr. Nagowski, the redeveloper council, pursuant to a letter I sent you on February 2nd. Today, I got to look at a response, which was extensive. And before I share it with the commissioners and make it a public record, I wanted to make sure I understood it. It seems to segue into the negotiations that are not our domain. So I'm reluctant to spread those negotiations across the public venue. But I did forward Mr. Nagowski's correspondence to our contract counsel, who's been assisting me with me towards the end of the RDA agreement, David Weinstein. I also sent to Howard Long. It wasn't provided to him. And because there are a lot of contentions or representations made about what's going on in the negotiations, Howard is the voice I trust most, because we are rowing for the same team. So please bear with me on that as I digest these updates, verify them, ask my questions, and then I can report to you all. So that's all I have to say about the redevelopers report from last month and the one that's coming for this month. As to the professional contracts, Josh pointed out that my task now is to revise the agreements from last year. All the same individuals were reappointed, and they are those that have been previously blessed by council, with the exception of an architect, simply because it has turned out that this development does not really need the services of an architect, and that's been confirmed by the Garrison outfit themselves. So we'll get those contract reviews and preparations, the reviews, double checking their insurance information done. It's pretty pro forma. Lastly, I did share with the commissioners a report of sorts from our environmental counsel, Deborah Rosen. And since I asked Josh to share it, I know this stuff is arcane. It's a little dense for me as well. But I think that since environmental issues were my primary challenge coming into this, and everyone's challenge really, and that I've been so careful about engaging top-notch statewide environmental counsel, I just thought I'd give you a little bit of background about this letter. hopefully preempting questions, but if you have questions after, fine. Deborah Rosen is with the Archer firm. She is a preeminent environmental lawyer and has handled cases all the way across the spectrum. She replaces Craig Huber, who served in that role and met with mayor and council as we went through the redevelopment agreement. He reviewed the entire record of the cleanup and blessed its compliance with the rules and regulations with which he was intimately familiar, having represented parties in multiple landfill cases. So we are in very good hands. We had previously asked Ms. Rosen to take a look at the $25 million insurance policy that has been obtained, paid for, and is presently in place, covering environmental liability for the property, which never had environmental insurance before. So it's covering the borough, which owns a large part of this tract, so let's call it a third. It covers the agency, which doesn't own any property yet, and it will do so into the future. She reviewed and approved that contract as containing standard policy provisions, standard caveats, but far more coverage than we demanded in our RDA. And I think that's probably likely an offshoot of the fact that the redeveloper wanted to attract the top-notch types of tenants that would be willing to come to a Brownsfields. And of course, that giant $25 million umbrella was probably designed to do precisely that. So it comes to pass then that we had an issue that came up with respect to these things called an HDSRF. Those are the liens that were represent funds paid by the NJDEP as part of various grants for the cleanup. Now, some of those were utilized by mayor and council for our own property. Well, the state does not charge municipalities, assess a lien for those grants. However, there were liens on the redeveloper's property, something in the neighborhood of between $20 and $25 million. And the provisions of the law that were historically in this deal were that the liens would be forgiven upon the borough taking title. This is even before my actual involvement in this matter. Upon the borough taking title, and they'd be forgiven, which made the deal go round. $25 million in liens on a property, and the debt service on that would have effectively negated any possibility for redevelopment. And throughout the years, I've seen correspondence between NJDP and the redeveloper, and with Mr. Messick as parties to it, where there were references to the fact that the borough may, at some point, construct a redevelopment agency like us, and that might be the agency that owns the property, and hence would want the liens released. So those documents are out there. I took no one's word for it. I read them myself. Nevertheless, and the redeveloper actually contended that, hey, these liens are going to go away, McKenna, so don't worry about it. Here's the law. Here's those old documents. Nevertheless, despite those arguments, I did not like the idea of not having an assurance. Why would we want property with $25 million liens on it? So I provided for a provision in the agreement that said that before we would take title, granted, they're not going to release a lien until we're entitled. Before we would take title, the redeveloper would provide us with a written confirmation from the state that the liens would be released upon our taking title. And our is now after the redevelopment agency had been constructed. Well, guess what? Some individual from the AG's office, not privy to any of the other historical documents, wrote an opinion letter saying, no, the municipalities, Deptford, Bellmawr, that administered the liens, and we administered all the liens across all the properties because that was the way this thing was constructed, they had to be entitled, even if it was only for a millisecond. And I wrote a letter brief citing all the historical documents, making all the arguments I could. Don Nagowski and I cobbled together an argument that was some breadth and length. And the DAG would not budge. The plain language of the statute says what it says. Despite all the historical agreements, long before my view, that said, we know a redeveloper's coming. So long and short of it is, presently, this agency has no problem with the idea that we have to take title. We had always intended so. To say nothing of the fact we have a $25 million insurance policy. But the borough and Howard Law have to look at this, and they had to be sure. So to that extent, we had asked Ms. Rose to take a look at this for us and to give us clear blessing on it. And she has done so. Now, before I asked Ms. Rosen, this preeminent environmental lawyer, to take a look at it, the Redevelopers Council had taken a position and indicated that as long as there would be absolutely no liability to the borough for stepping into title on the other properties not owned, and then right back out at the same exact settlement, whereupon the $25 million lien would be released as settled, as title then passes to the Bellmawr Redevelopment Agency. It's just kind of a robotic construct, but it's what the DAJ wants based on a strict rating. Okay, well, that's fine. However, let's make sure that there is no liability, and we're not going to rely on the Redevelopers Council. We relied on our own. And this letter, the long and the short of it is that she went over it very closely, and she indicates that although the Redevelopers Council may have overstated things, the only possibility, and lawyers don't like to say only, the only legal possibility for any liability to the borough is if in the precise moment between the deed being signed by the governing body and then handed to the redevelopment agency, if somewhere in there the borough did something wrong. And in such event, the $25 million would be there. And she indicated, I think she called it very minuscule, if any, risk. So we went to the trouble of asking for the confirmation in advance. We went to the trouble of demanding the insurance policy, but we also went to it's kind of belts and suspenders. We wanted to make sure, it's been my goal since the beginning, that there would be no liability that could be even considered reasonable on the part of the borough. Now, this has to pass muster and Deptford as well. This is not our decision, folks. I just wanted to share with you the legal opinion that our environmental attorney has authored at my request in order to further the progress of this deal. Howard Long has this. I have little doubt that he will share it with the governing body, and then eventually this will wend its way over to Deptford, where they're going to be expected to do the same thing if they expected to get any money out of this deal. It is a little dense. It does seem silly that they agreed to these things before, but now they want this construct. I can tell you that I am aware that the DEP, in even the worst circumstances, has no interest in chasing municipalities and governments. They don't do it typically as generators or even operators, let alone in a millisecond of ownership. But again, caution being my hallmark here with respect to environmental issues, I wanted you all to know that I'm on this issue. I'm staying on it, and taking a lien, taking a property with a $25 million lien is a non-starter. But any exposure to the governing body is something that I'm also looking out for and cautioning against, unless and until we can, as we have here, rule out any difficulties, notwithstanding $25 million in available insurance. So look, I would welcome any questions, and if you want to do that sometimes on your own and you want to call me, that's fine too, because I may be a little hedgy on my opinions with respect to potential, litigation type stuff regarding this. But I'm comfortable with the situation as it is. But mayor and council have a right to their own due diligence. I'm sorry I talked so long, guys, but if I had more time, I would have been quicker. That's my report.
All right, thanks, Mike. Any questions for Mike before we move into new business? Nope. All right. So just one item on the agenda for this evening. A resolution of the Bellmawr Redevelopment Agency, resolution number 02:020-24, authorizing payment of outstanding bills.
I make a motion, we pay our bills.
Thank you, Mr.
Second it.
Whitman. Thank you, Mr. Patel. This is a roll call, so we'll do we'll run down the line here. Chairman Philippek,
Yes.
Vice Chair Bider,
Yes.
Commissioner D'Angelo,
Yes.
Commissioner Whitman,
Yes.
Commissioner Patel.
Yes.
All right. That concludes new business. I will go to public portion. Don't believe anybody is on the line, but we'll give it 3 seconds or so. All right, that'll conclude the public portion, and that'll bring us to an adjournment. Have a motion?
I make a motion to adjourn the meeting, Josh.
All right, thank you, Mr. Patel. Just need a second.
Second.
All right, thank you, Vice Chair Bider. All in favor signify by saying aye.
Aye.
Any nays? Ayes have it. Meeting's adjourned.
Thanks for coming on, guys.
All right.
Have a good night.
Thank you,
All right.
gentlemen.
Absolutely.
Thanks, fellas.
See you guys.
See you, everybody.
Thank you. See
All
you.
right.